If you are working as hard as you have ever worked in your career, and somehow you feel like you're finishing every Friday more behind than when you started, this episode is for you. It is likely not a productivity problem, likely not a marketing problem. That is likely a client selection problem. And it is a discipline that does not get the attention it deserves in legal training. I am Robert Bunn. This is estate planning for lawyers. In the next 20 minutes, I am going to give you the framework. By Monday morning, you will know exactly which clients are building your practice and which ones are actually costing you. Quick note before we begin. Nothing in this podcast is legal advice, and no attorney-client relationship is created by listening or watching. There's a full disclaimer at the end of the episode. In this episode, episode 6, I'm covering chapter 4 of Time Management for Attorneys, a lawyer's guide to decreasing stress, eliminating interruptions, and getting home on time by Mark Powers and McNalis, published by Atticus. The chapter is titled Proactive Strategy 4, Select Clients Wisely. If you do not already have a copy on your shelf, I would encourage you to pick one up. In chapter 3, we worked on goals. We took the vision statement and we broke it into stepping stones and put those stones onto the calendar, calendared and committed. But here's what nobody tells you. You can have the cleanest goal grid and the most disciplined calendar you've ever kept, and you may still feel like you're drowning. Why? Because the wrong client can erase a perfectly planned week in a single afternoon. That is what chapter 4 is about. Powers and McNalis make the case that client selection is a time management discipline, not a sales discipline, not a marketing discipline, a time management discipline. By the end of this episode, you will have a framework for screening clients before they ever sit down across from you, a method for grading the clients you already have, and a path for cleaning up your caseload that has gotten away from you. And this is by Monday morning, not next quarter, Monday. Powers and McNalis opened the chapter by applying Pareto's principle to your client base. Their argument, paraphrased, is that roughly 80% of your income is going to come from roughly 20% of your clients. Sit with that for a second. If that is true, and in my experience it is, then most of the work you're doing is being done for clients who are not actually paying for the practice that you want to build. The clients who built it for you are quietly tucked into a small group, and the rest are consuming the hours it should be going to the clients that built your practice. The authors described this 20% as having certain characteristics. They're recognizable, and once you can recognize them, you can start to target them as potential future clients. The same is true in the other direction. The clients who are draining you also have characteristics. The chapter lists several, and I will paraphrase the ones that hit hardest for me. The endlessly needy client who has to talk through their situation again and again and again. The client who refuses to take any responsibility for the situation that brought them to you. The client who is being deceptive, often to protect themselves. The client who withholds information out of mistrust. The client who is so consumed by their crisis they cannot follow simple instructions. If you're listening to or watching this and the thought of a particular problematic client just popped into your head, that's the point. I learned the discipline of saying no at the front end years before I read this book. When I was an assistant state attorney for the 10th Judicial Circuit in Polk County, Florida, the white-collar crime cases came across my desk. The decision I had to make on every file was not only whether I believed the conduct happened based upon the evidence before me. It was whether the state could meet its burden to prove each element of each count beyond and to the exclusion of every reasonable doubt. That standard exists for a reason. The stakes in a criminal case are often a person's liberty, and that is a weight you do not take lightly. So part of the job was being brutally honest and transparent about what I could actually prove before I charged. Sometimes that meant telling a victim, despite how difficult, that I could not move forward based upon the evidence presented. The discipline was understanding the facts and circumstances and when necessary or appropriate, and in the interest of justice, saying no at the front end. Powers and McNalis are pointing at the same important concept as it relates to your practice. Get it right at the front end, before the engagement letter, before the clock starts, before the obligations attach. The work of saying no at the intake conversation is a significant step of doing what is right for you and your practice. When you obtain an engagement letter, you are committed. You're responsible for that client to some extent, whether they pay you or not, whether they cooperate or not, whether you like them or not. The hours that a particular client consumes are hours you cannot give to anyone else. That is a time management cost of a yes to a client that really should have received a no. And it costs more on the back end than it would have on the front end. The tool Powers and McNalis offer in this chapter is something they call a Client Scorecard. It is their framework and offers incredible insight and a lens from which you can begin evaluating your clients and their impact on you and your practice. The structure, paraphrased, ranks clients across categories that matter to your practice. The author suggests 5 core categories, and they suggest you adapt them to your own work. The 5 categories Powers and McNalis propose are cooperation credibility, ability to pay, case value, type of work, and referral source. You give each prospective client a letter grade, A through D in each category. A clients are the best across the board. D clients are the worst. Some attorneys will weigh one category especially heavy. Powers and McNalis note, for example, that some lawyers treat ability to pay as a deal breaker. A client who is in an A in every other category but not pay immediately gets dropped to a D. Other lawyers treat opposing counsel as a deal breaker because some opposing counsel will turn even a clean matter into a war of attrition. The authors mention that some lawyers handle that by simply raising their fees openly when they know the case is going to require more work because of the counterparty who's on the other side. I thought this was a smart approach. The reality is that some matters cost more to handle for reasons that have nothing to do with the merits, and clients deserve to know that going in. The chapter also gives an example of how a family law practice will customize a scorecard with categories like availability of assets, level of spousal animosity, and attitude towards children, among others. See the book directly for the full list. These criteria enable you to build a scorecard that filters for the kind of practice that you want to have. The scorecard fosters a discipline of actually grading a prospective client before you say yes. Powers and McNalis devote a substantial portion of the chapter to red flags. I'm going to paraphrase the categories. See the full list in the book if you want it. The authors group the warning signs into 2 broad buckets: financial red flags and personality red flags. On the financial side, the authors flag patterns like prospects whose first question about cost, prospects who resist a consultation fee or a retainer, prospects who hold out the promise of future work to negotiate a discount, and prospects who mention they are switching attorneys mid-matter. The authors also flag distant family members showing up at large matters. On the personality side, the authors flag customers that show up on a full crisis mode, demanding immediate attention. The prospect whose anger is wildly out of proportion for the matter. The prospect who is asking you to guarantee an outcome. The prospect who cannot hear an objective appraisal of their case. And the prospect who refuses to take responsibility for any part of the situation. They brought them to you. Here is the line in the chapter that hit hardest for me. I thought it was a great line by Powers and McNalis. The authors observe that warning clients do not sneak into your clients. They walk in raving red flags. Nevertheless, you let them in anyway, possibly because you need the money and because you're hoping, as Powers and McNalis point out, that the uneasy feeling in your gut is just heartburn. Begin to trust that uneasy feeling. That is not just good advice for client selection. That is good advice for life. And it turns out the science backs it up. A 2018 paper, Bonaz, Bazone, and Palacier, in Frontiers of Neuroscience, confirms that the vagus nerve, the primary neural pathway connecting your gut to your brain, is composed of roughly 80% afferent fibers, the ones carrying signals, again, up from your gut, and 20% efferent fiber, so lung carrying signals down. That means roughly 4 times as many fibers are wired to send information from your gut to your brain as they are from the other way around. When something feels off, that is not nothing. That is data. So when a prospective client walks in waving red flags and your stomach tightens, listen to it. Your body may have noticed something before your mind caught up. If any of this is landing, the like button below helps other attorneys find this episode. It would also mean a lot to me, and I thank you for considering it. And if you have ever ignored that uneasy feeling in your gut, tell me about it in the comments. I read them. Powers and McNalis make a structural recognition that I want to call out because it's operationally important. The recommendation paraphrase is that the screening should happen on the phone before the prospect ever gets a consultation appointed. And it should be done by a trained intake person, not by you, ideally. Why? Because your time as the attorney is the most expensive resource in the practice. If you're spending an hour a week on initial consultations with prospects who turn out to be D clients, you're losing the equivalent of more than a full work week every year on people who are never going to retain you, or who are going to retain you and then make you wish you had not. The chapter is clear on this. The intake person should have the scorecard in hand and should be working through it on the call. For solo and small firms, this is going to look different than it does for a mid-sized firm. You may not have a dedicated intake person. You may be the intake person. That is fine. The principle still works. You build a script. You ask the questions. You take the notes. You grade the prospect. And then you decide whether to schedule the consultation. The authors include a sample intake script in the chapter, and they include a more detailed initial consultation form. I'm not going to walk through those line by line. The forms in the book are worth seeing in their original layout. Every practice is going to need to adapt them for their own practice. But the structural lesson is the one I just gave you. Build a script, use it, grade the prospect, then decide. Now we come to the part of the chapter that takes courage. Powers and McNalis make the point if you have been practicing without this kind of filter, your existing caseload is probably full of C and D clients. They tell a story, which I'll paraphrase, of an attorney who attended one of their seminars, went home, ranked his entire client list that night, and discovered that 80% of his caseload was C and D clients. That is not a time management problem. That is a structure problem. The authors lay out a 3-step process for cleaning up your caseload that has gotten away from you. I'm going to paraphrase it, and I'm going to add a strong caution as I do, because this area is governed by your local bar rules, and those rules vary by jurisdiction. Step 1, go through your client list and rank every active matter A, B, C, or D. The A and B clients you keep. The C and D clients you take a hard look at. Step 2, for your borderline C clients, the authors recommend a direct conversation. The client may be a C because of correctable behavior. They're not paying on time. They're not producing requested documents. They're canceling meetings. The author suggests that some of these clients can be rehabilitated to a B level with a candid conversation. Others cannot. And the authors recommend referring those clients out with a careful caveat that you should not be referring non-paying clients to your colleagues. Step 3, for your D clients, the authors recommend letting them go in writing, following the disengagement protocol that applies in your jurisdiction. Here's where I am going to pause and be very careful. The chapter includes several sample non-engagement and disengagement letters. They are taken from a Florida bar publication and are reprinted in the book with permission. I'm not going to read them in this podcast. I will say that the chapter contains useful examples for declining a case at the front end, declining after research or investigation, and disengaging from an existing matter for non-payment. If you're going to disengage from a client, your governing authority is your bar's professional rules and any applicable local rules of court. Read them and follow the protocol in accordance with what is ethical and appropriate. Document everything. Send the letter. Keep a copy in the file. The chapter ends with a line that I want to paraphrase because it summarizes the whole point. The authors make the connection between the quality of your practice equating to the quality of your clients. Imagine, the author suggests, what your practice would look like if it were composed entirely of A and B level clients. They pay their bills. They appreciate the work. They cooperate. They show up on time. They send you good referrals. That is not a fantasy. That is what happens when you start applying the screening discipline at the front end. Every negative trait of a client costs you time. Time persuading them to trust you. Time calming them down. Time chasing payment. Time you could have been giving to the clients that are actually building your practice. This is not just a marketing question. This is a quality of life question. Here are 5 things you can do this week to put Chapter 4 to work. 1. Go through your active matter list and rank every client A, B, C, or D. Do not overthink the categories. Use the 5 categories Powers and McNalis suggested if you want to, or use your own. Just rank them. 2. Count your C and D clients. Look at the percentage. That number on its own is going to tell you something about why your weeks feel the way they do. 3. Build a 1-page intake scorecard for new prospects, the categories that matter to your practice. A through D in each category. Print it. Put it next to the phone. Use it on the next intake call. 4. Identify one borderline C client whose behavior you have been tolerating. Schedule the candid conversation. Either they correct the behavior or you start the disengagement process under your local rules. 5. Read applicable bar rules. Know the protocol before you need it. Disengagement is not a thing to figure out in the middle of doing it. Do those 5 things and you will have done some incredible structural work on your practice. My personal takeaway from Chapter 4 is this. What Powers and McNalis are pointing out, and what I'm still learning, is that a full calendar is not a successful practice. A full calendar of A and B clients is a successful practice. A full calendar of C and D clients is a slow road to burnout. The discipline of saying no at the intake stage is the same discipline as filing a charging affidavit. You're committing the resources of an entire system, yours. Choose carefully. In the next episode, we move into Chapter 5. Powers of McNalis turn from the question of who you serve to the question of when. We will learn scheduling habits to harness and better harness our time. To reiterate what was said at the beginning, nothing in this show is legal advice, and no attorney-client relationship is formed by listening or watching. The information presented here is general and educational and is not a substitute for advice from a licensed attorney in your jurisdiction reviewing your specific facts. The views I share are my own on behalf of Bunn.Law, PLLC. All references to time management for attorneys, a lawyer's guide to decreasing stress, eliminating interruptions and getting home on time by Mark Powers and Sean McNalis, published by Atticus, are made for commentary and educational purposes only. All rights in that book belong to their respective owners. My discussion is commentary and analysis, and neither the authors nor the publisher have endorsed or affiliated with this show. I recommend everyone buy a copy. Subscribe to Estate Planning for Lawyers so you will not miss our next show. I'll see you there.